I once had an old attorney explain to me that when you take a deposition, here's how you decide who won the depo. If the attorney taking the deposition says more than your deponent, the witness, then the witness has won. If the witness says a lot more, and when you look at the transcript, then that attorney has won. So this is truly a case where less is more. Welcome to episode 113 of the Weekly Docket, a podcast by the Silverman Law Firm, where we talk legal news and practical law. Today is March 13th, 2026. I'm Phil Silverman, owner of the firm and your host, and I'm joined by Chris Hild, who's our firm's supervising attorney. Chris, we have another really boring show today, I'm afraid. We have to talk about discovery. Fairly miserable. But yeah, we got to do it. Surprisingly,
we'll run off the listener.
Surprisingly, our last show on summary judgments was more popular than I expected. I think, again, a lot of our listeners are attorneys, but I think lay people, our clients especially, they do want to know about this stuff. So that's a good sign. But I will tell you, is not near as popular as some of our other shows where we're talking about entertainment law and what P. Diddy has done or whatever, but not that show today. Let's get started with what's on our docket. We're going to be talking about discovery in Texas. We're going to be talking about the different discovery levels. This is part of litigation. It's part of a lawsuit. So different discovery levels. We'll talk about initial disclosures. We'll talk about expert designations, and we'll talk about written discovery. If we have time, we may tackle some other discovery topics, but it's all about discovery. So let's go ahead and get it kicked off with discovery in Texas. Chris, generally speaking, if you were going to tell a lay person, a friend, who's been sued, and you say, okay, we've answered the lawsuit and now it's time to start discovery. And your friend's like, well, what is that? What would the answer be, Chris?
Discovery generally, I would describe as your opportunity to learn about the other side's case and the other side's opportunity to learn about your case because, in Texas, we don't do trial by ambush. We expect the parties to work together. Anything that you don't produce that is requested, you are not going to be able to produce at trial. So get all your stuff together, be ready to produce, ask a lot of questions of the other side so that you have a comprehensive view of their case and everybody goes into trial eyes wide.
I'm glad you used the phrase I thought you might use, because I think when we were all in law school, we heard we don't have trial by ambush. And lay people that watch a lot of television or lawyer shows, they're used to the dramatic courtroom scene where the witness or the attorneys are surprised at something and it changes the entire case. That doesn't happen because the attorneys, we know everything that's going to come out in that case before it comes out, because most of the time we've done extensive discovery. Although, Chris, not all the time. If a client's on a budget and can't afford to take a deposition, I suppose we call those Wild West trials where we just go down there and I've never deposed this witness before, but my client didn't have any money, so here we go, right? So you do have some of those, but
for the most part, like you said, there's no, well, what about this document? If there's that key of a document, either they withheld something and are about to be sanctioned, or you missed something crucial. So, and surprise witnesses. And like you just said, witnesses have to be disclosed. And not only do I have to know who they are, if they're that key of a witness, I've probably already sat in a room with them and had a 2-hour conversation with them where all of their testimony is already on the record. And the only reason I'm asking again is for the benefit of the jury. I know what they're going to say. And if they don't say what they already said, then I get to impeach their testimony.
Yeah. It's that dramatic scene from the movies, and the defendant calls, Jill Smith, and there's a gasp, in the courtroom, and everyone's surprised. And she walks down, to take the witness stand with sunglasses on. And no, that's not the real life. I'm afraid. So yes, we do know. Okay, so that's what discovery is. We're learning about the case before we have trial. Um, Discovery levels. This has not always been a thing in Texas. It's relatively new. I can't remember how long we've been doing discovery levels in Texas, but we have 3 levels of discovery. All right, level 1, level 2, and level 3. Now, if I had to paraphrase, I would say level 1 is for small cases. That's like when the only monetary relief of $250,000 or less. And you can't ask the court for anything besides money. So it can't be an injunctive relief. You can't ask the court to do something. It can only be, I just need money. It's under 250, and then you get level 1, and it's kind of some shortened discovery process. Okay. And then you've got level 2, which is kind of the default. Everything goes to level 2 if you don't specify. And then you have this sort of the more normal limits of discovery in level 2. Like you get 50 hours of depositions in level 2 plan. And in a level 1 plan, you only get 20 hours. So the idea is level 1, you don't need all this expensive discovery because it's a small dollar case. That's the idea. Now, and then level 3 is court order. Those are for generally larger cases, and the court will sign a specific order for a custom tailored plan. So, Chris, I mean, a couple of questions for you. I always see our cases as level 2. I very rarely see a level 1 case, but shouldn't it be that if there's a case that really is for monetary relief of 50 grand, shouldn't it be level 1? I mean, do you always just put level 2?
Well, we've always put level 2 because, you and I graduated in the late 2000s. Discovery rules have changed a lot since then, and they really are trying to push things to level 1. You're right. The default has always been level 2 since we started practicing, but now it is trending a lot more towards level 1. Hey, we're not going to put you in the middle. It's going to be level 1, the default. Level 2 is going to be court ordered, and level 3 is going to be, the big cases that big companies fight over with 16 lawyers. In cases in counties like Harris County that issue a DCO, I'm not sure that the discovery level is as relevant. But for things like you're saying, deposition hours and number of interrogatories and stuff like that. But the deadlines in a lot of counties are going to be set by either a scheduling order that the parties agree to, or the court's just going to issue you one and say, here's your DCO, follow it.
Yeah. So in practice, what really happens is almost everyone pleads level 2. The big counties issue a docket control order, and the docket control order will say, well, if I don't talk about a date in here, then the rules of Texas civil procedure apply. So you end up with like this hybrid court order level 2 thing. Would you agree with that generally?
Yeah, I think, because they're saying whatever we don't address, go to the rule. Again, like hours of depositions, those aren't addressed in docket control orders, but the court wants you to go to mediation. The court wants experts designated by a certain date. They want joinder by a certain date. And they give you a trial, which in my opinion, every county should do, but not every county does.
Right. So what happens if you plead level 2 in your petition, the other side doesn't object, doesn't care, but you only have $40,000 in controversy, obviously, and you go all the way to trial and you're trying the case. It's just a moot point. It doesn't matter, right? Because
I agree. I mean, there's been the very rare occasion where someone's fought me on, well, this should be level this. Really, the only reason you would do that is if you're trying to expedite the case. Yep. But if people just want to be difficult to be difficult, they can. But fighting over discovery levels. And then once you're in it, like we talked about, the deadlines are going to be the deadlines. You're not going to fight over stuff like that at the end. Okay.
So those are your different levels, right, of discovery. Generally speaking, if the court doesn't issue a docket control order, and if they do issue a docket control order, then what's going to happen? The docket control order will probably specifically say when the discovery period ends, which for young attorneys out there, that's really not the operative date, because it's like, oh, I've got, my discovery period ends in 10 days. And I better get some discovery out. Well, no, you've waited too late, because it has to be done where the other side can respond before the discovery deadline. So you would actually have to get the discovery out 30 days before the end date. I think that's an important nuance I wanted to mention. But if the court does not issue a docket control order, then the rules are going to govern. And if it's the level one, which is the expedited level, then you have 180 days after initial disclosures are due. And if it's level two, then you've got 9 months after initial disclosures are due. Okay, so that brings us right into initial disclosures. Chris, what are, and again, talking to a friend, layperson, what are initial disclosures?
Well, that's another thing that they recently changed. You used to send a request under Rule 192 that said, give me a bunch of things. And it was like 7, 8, 9, 10, whatever things already laid out in the rules that you would just send that request. And, it's already deemed that these are not objectionable requests, and the other side answered for you. Since we've been lawyers, that has changed, and you don't even have to request that anymore. It's automatically due 30 days after your answer. You have to provide, these things that are laid out in the rules of civil procedure. And most of them are simple. Like, what are the names of the parties, so that we don't get, like you just intimated, to the end and someone says, you got the wrong guy. Haha. Like, confirm for me that the parties are named correctly. Do you believe there's anyone else out there? What are your general legal theories? And everybody just says, see plaintiff's petition. No one actually answers that question. What are the witnesses? Well, I'll get those to you later. All documents pertaining to the case. Okay, I'll give those to you later.
Mm-hmm.
But that's usually what it is. It is a way of making sure the other side doesn't hide anything, like we just talked about. It's just you must produce documents that you believe are relevant to your claims. And if you don't do that, the judge is going to have some words for you and is not going to let your evidence in.
Yeah. If initial disclosures, a bunch of basic, you can think of the initial disclosures as basic stuff to get out of the way that everybody should have initially. And parties, potential parties, damages, supporting documents, if there's insurance, things like that. Legal and factual, but your legal theories. I do usually see, if you're a plaintiff, replying or furnishing initial disclosures, you would do C petition. Chris, for the defendant, you don't, because in Texas we have general denials. I don't see it as much as the defendant that just says C answer, but I guess you could put that.
Yeah, you could put, we deny all claims in plaintiff's petition. I don't bear the burden.
Yeah.
And I've been sued. What do you mean? What's my legal theory? You sued me. My legal theory is no.
Because you do like the C general denial. That's fine. I mean, I sometimes
I've changed a lot. I used to want to explain, and then it's like talking to the police. They don't care. They're not looking for your innocence. They're looking for your guilt.
Right.
So the more you say, the more will be used against you.
Less is better. Less is better. That's a good point. I don't know if we're going to talk about depositions in this show, but I once had an old attorney explain to me that when you take a deposition, here's how you decide who won the depo. If the attorney taking the deposition says more than your deponent, the witness, then the witness has won. If the witness says a lot more, and when you look at the transcript, then that attorney has won. So this is truly a case where less is more. But yeah, back to initial disclosures, all the basic stuff, your deadlines, those are going to be due 30 days after the answer is due, and they're mandatory. If you're late, there's not really a consequence, but unless you're really, really late. So then you could waive some things, but a couple of days late, probably not a real big consequence there. But all right, expert designations. That's our next topic. Chris, this is one near and dear to my heart. If you need experts, you better designate them. The rule is 195.2, Texas Rules of Civil Procedure. And you typically, if you're a plaintiff seeking affirmative relief, you got to designate your experts 90 days before the end of the discovery period. If you're a defendant, then 60 days. Chris, give an example of what and when you might need an expert. I mean, and what that looks like. Give me some, like, if you had a real estate case that was about title opinion, what kind of experts might you want there?
You might want a title examiner or something like that. I mean, really, it's the standard is going to be anything that a layperson can't explain.
Mhm.
We all may watch lawyer shows or medical shows, but the reasonableness of legal fees must be testified to by a lawyer. The reasonableness and necessity of a medical procedure must be testified to by a doctor.
Mhm.
We get into, can any layperson read a title opinion? Maybe, but do you run the risk of a judge saying, hey, this is way too technical. I'm not going to just let your person
Mhm.
testify about this. We had one recently where our client wanted to testify to the value of her home. And the judge said, you are not qualified to testify to the value of your home. You didn't designate an appraiser. And the only person that can testify to the value of your home is an appraiser.
Mhm.
And, you know, that, sometimes that happens. So out of an abundance of caution, if it's something that you run the risk of a layperson maybe overstepping their bounds, you want to get an expert.
Yeah. Yeah, and that's a good point. When in doubt, designate an expert is always my rule of thumb. It's tough to when you're looking for experts out there and take your example of an appraiser. Not all appraisers want to do expert testimony, so you have to find some appraisers willing to be an expert on the day you designate them, and then also at the potential date of trial or the potential date of being deposed, which is more difficult than you might think, Chris. So getting you.
No, it's very difficult, and these people are not cheap either. A lot of the cases we don't run a whole bunch of multi-million-dollar cases. We got a lot of cases that are less than six figures.
Yeah.
So I got to pay an expert 10K. That really affects how I run my case because there's not a lot of room to keep the client happy while also running the risk of what we don't even win. What
Yeah.
if we spend all this money and no win?
Yeah.
We're not
Yeah.
more accident journeys working on contingency.
Yeah. Yeah. That's right. Just to get an appraiser, surveyor, or anybody like an architect, those are expensive people, and that you have to have a budget for that. Now, finding them, designating them doesn't really cost a heck of a lot, but you can certainly, designate them. And then the problem becomes, okay, well, now we need opinions. Now they need to be deposed and then they need to go to trial. Then you're talking about some real money. But to prove certain elements of a case, normally it's damages, could also be something substantive. You're going to need an expert. So, all right, let's talk a little bit about sort of written discovery. Interrogatories, Rule 197. Written requests that are other party must answer in writing and under oath. Chris, how do you like to use interrogatories? I mean, do you like if you don't have a ton of money, you can't take a deposition, or your interrogatory is like the next best thing, or do you try?
Yeah, so I would. I like interrogatories. You only get 5 of them. You're not really looking for a gotcha,
Mm,
but you're really just looking to pin people down, like explain what happened. That way
mm,
you can't change it later. Tell me what happened. Tell me who was there. Tell me who signed. Tell me what day it was. You know, give me a list, of all the people that know this or something that you're just really information gathering.
mm,
Um, I like to use them in conjunction with a deposition because now I already have the answers of the questions. Now, if I'm going to go into a deposition, I've got a jumping off point where now I can kind of explore your side a little bit more and then kind of pin you down or get you with something that's inconsistent. Say, now, wait a minute, you said this,
mm.
now you're saying this, or you're trying to fit these two things together, but they don't really go together.
Yeah,
So,
that's a good strategy. Send the interrogatories out first before you do your deposition. You got a little bit of further information going into the depot. So that's a good way to use that. Um, in level one discovery, you get 15 questions. Level two, you get 25 interrogatories. How do you see you always get in a fight about these subparts? So can you send somebody 25 questions with 10 subparts A, B, and C to each one, and then you actually end up with 250 questions? Is that okay?
No, you can have subparts though. They just have to be, I forget the word that's used. It's not distinct, like discrete.
Yeah.
It has to, like, I can say, like I just told you, describe the events of the signing of this will. Your answer should include the location of the signing, the person's present, the name of the notary, the time of day. I can say your answer should include all of these things, but really what I'm asking is, tell me about the will signing.
Yeah.
I can't say, tell me about this and this and this
Right.
and this and call it all the same question. That you can't.
Yeah, that's not a subpart. So the key
Right.
is subpart. Okay. All right, let's move on. Request for production. This is Rule 196. This is other party to provide physical evidence. Usually it's documents, emails, things like that. Could be an object. Looking for paper trails, tangible evidence. Level 1, you're limited to 15 requests for production. Level 2 really has no numerical limit, but it has to be proportional, I guess, to the damages of the case, right, Chris? So, um, how does this differ from the initial disclosures? Because in initial disclosures, there's somewhat of a document request there as well, right?
Yeah. I mean, I don't have a great answer for that. You would think that anything relevant to the case should be produced up front. But if they're saying, well, hey, here's what I need to prove in my case, but you want, you know, email communications with the real estate agent, you want negotiations, you want drafts of the contract so you can see what was changed.
Mhm.
They're just saying, well, here's the contract, you breached it.
Yeah. Yeah.
They produce the contract. They're not necessarily going to produce the emails with the title company
Yeah.
for why closing didn't happen. So stuff like that. So you're kind of going beyond what the other side, the plaintiff, is going to put in front of the court to say, okay, well, yes, closing didn't happen, but I need the emails with title company explaining why it didn't happen. You can't just hold my guy liable because it didn't happen.
Yeah. All right. That's pretty basic stuff on request for production. There's not, a lot to that. But I will point out that in some of these gigantic cases, Chris, your doc production can just go on and on. You talk about thousands, maybe hundreds of thousands of documents. And that's how you needed these doc review attorneys these attorneys to go through these documents and say whether or not, they're responsive. So, um, you know, now we've got AI kind of cutting into that doc review market, but documents can be costly if you're talking about gigantic cases. Smaller cases, you're probably not talking a lot about documents. But let's get into requests for admissions. Rule 1.
Word, you're going to cut that out.
No, we'll do requests for admissions.
I want to rant about
Everybody
admissions.
loves requests for admissions. Rule 198.
Hey, that's very
190, it's basically a statement. It's like admit or deny that you were the office at so and so date at so and so time. That's probably an appropriate request for admission. Sometimes you see crazy things, admit or deny, you are liable in this matter. That's not, that's not an appropriate one. Talk a little bit about that, Chris.
that causes me to have physical reactions to those. That is, dirty is not even the word. It's just, you don't know what you're doing. If you're asking questions like that, admit you reached the contract, admit you owe $78,000, admit you have no defense. All those are impermissible. All those, the case law specifically says you may not use requests for admissions for that purpose.
Mm-hmm.
That is not what these are for. It is admit this is a true and correct copy of the contract so that we can get that out of the way so that for the next 9 months, we both know no one's going to argue that this is a contract. Admit you signed the contract. I want to know that at the very beginning. So, because I want to know, okay, you're agreeing you signed it. You're not going to come up with this is forged. And if you are going to say it's forged, I need to start exploring that from day one. I don't want to be surprised by that 9 months down the road. That's what admissions are for. It's supposed to be admit we entered into this contract, admit no money changed hands. I don't care about your defenses. Don't tell me why no money changed hands. Just say, okay, we can agree no one paid. That's what the fight is about, but we can agree no one paid. You're not going to come back later and say, oh, yes, I did pay. But don't say admit you breached. Admit you don't have a valid defense.
Right.
Admit what you pled in your petition is wrong. Well, why would I have pled it in my petition then?
Yeah, that's exactly right. And sometimes you even, spoiler alert, attorneys will miss deadlines And sometimes you see an attorney miss the deadline. Sometimes it's not the attorney's fault. And the other side's like, I've got them and they didn't respond to my admissions and they're ruled deemed after 30 days. So, and I asked them I asked them and admit that I win everything. Texas Supreme Court has said that, no, that's not what they're used for. That's what Chris is speaking of. I think the seminal cases, Chris, if you're interested, those were mostly pro se parties that missed the admissions deadlines. They were pro se at the time, but I don't think that's relevant to the Supreme Court's opinion. But I just thought that was interesting because I read one of those the other day. But, all right, Chris, that was a very boring show, very useful.
I disagree. I think that was an exciting show. I think people are going to love it.
You always underestimate how many law students and how many lawyers that are not trial lawyers that are out there listening to us, Chris, and are learning. I mean, I'm not saying it's like, we're these amazing guys in this great show, but
yeah, I hope people aren't learning from me. That's scary. I take it all back.
They are. And there's even other litigators that are out there. A lot of solo practitioners listen to the show and they email me, Chris, and they're like, hey, it's so lonely being a solo. And I heard your show on summary judgments or discovery. And they're like, you confirmed a lot of things that I was thinking, but just never had anyone to ask. So, I mean, I had just before the show, Chris, we had a white collar criminal guy who presented a CLE, and it was about collecting, judgments for, I think, restitution. And he's like, oh, I saw this video that you did on homestead liens years ago or whatever. And like, I sent it out to the audience in the CLE, the YouTube video. And we don't remember shooting that. I mean, but it was useful. So I'm always surprised by what people find interesting and useful in the show. And it's not always, P. Diddy being, P. Diddy's criminal trial, believe it or not, because the press, the mainstream media has that covered. There's documentaries and all that. Nobody's talking about discovery in real world context. So anyway, I feel like we've done good work. That brings our show to a close. I've been your host, Phil Silverman. Chris Hill has been my co-host today. Like us, follow us, review us wherever you get your podcast. And as a reminder, nothing in this show is to be considered legal advice, and this has all been for entertainment purposes only. If you have a legal question, email us at info@silblawfirm.com. That's info@silblawfirm.com. And tell us you want it publicly answered in the podcast. Everybody have a great rest of your day and weekend.